I tell you, Bob, that is one broad, important. See, you've heard me say this, and I still won't, and I hope the biggest majority of my fellow agents that don't agree with me on this, but the states that have lawyers involved with all escrows are on the right track. Because I can guarantee you there's so much that's not explained through the escrow process. We do the very best we can with our contracts, but there's so much that goes on between the time of going into that contract and escrow closing. And it's just that buyer and seller needs all the advice that they can get. And whether it's with their own personal lawyer, but their lawyer and their CPA must play a role. And for the protection of the buyer and seller, they need legal advice. We're the first to say, hey, they're buying the most expensive thing that they'll invest in for the rest of their life. And the amount of advice, man and his wife, community property state. Well, there's a little bit more to it than that. Sorry, Carmen, please don't boot me to the curb.
Okay, set him straight, Bob.
No problem. No, but you're absolutely right. You know, I was a broker for a lot of years before I became an attorney. And so I've been out there in the trenches. And I know that as a broker and as an agent, you know, you learn things. You learn a lot. If you take your profession seriously, you learn a lot. And you think you know things, and you don't realize sometimes that you can cross the line and be practicing law and really, really expose yourself to some issues that could find you in court or financially in a bind at some point in time. So I'll just, you know, the vesting doesn't take a lot of time to cover, but I think I should mention a few things about it. So it's real easy if a single person is buying a piece of property in their own name, the vesting is probably going to be in their name. The trouble comes in is when you have two people buying a piece of property together, and they may be married to one another, they may be business partners or friends, and so there's various ways that they can take title. So other than a single person as their sole and separate property, when you get two people or a married person that's taking it in their own name, you've got some potential issues. So a married couple can take property as joint tenants, and that's automatically with the right of survivorship. They can take title as, they could take title as tenants in common, which means they both own an undivided interest in the property on title. There's some legal aspects to it. You know, we are a community property state, but that doesn't affect how they take title, and how they take title can affect things down the road. They can take title as joint tenants, which automatically has a right of survivorship. When one of them dies, the title goes to the other. And they can take title as community property. We're a community property state. And they could take, when they take title as community property, it's the same as taking title as Mary and John Smith, who are married to each other. But there's another form of community property vesting that they could have, and that's community property with the right of survivorship. So when a couple takes title as community property, that's it. It doesn't mean that there's a right of survivorship. It means that it's community property, that they're acknowledging that they're married to one another. And so that when they die, they each, say the husband dies, the wife owns her half and at least, and probably half of the husband's half. Now there are some circumstances where if it's the family home, it could be the whole thing. But basically what it means is that a portion of the deceased spouse's estate is distributed by their will or by their trust. But if they have community property with right of survivorship, then it automatically goes to the other spouse, just as if they were joint tenants. So there's a difference, and I'm not a tax guy, but there's a difference between joint tenancy and community property with the right of survivorship from a tax basis or a tax standpoint. Joint tenancy, the deceased party's interest gets a step up in basis when they die. So it affects capital gains on the property. So it steps up to the market value. Community
market or 50%, Bob.
Pardon me?
Market or 50%.
Well, the deceased person's interest, I understand, goes up to market.
Right. So then.
So the whole thing was, we don't know. It depends if they own the property for 50 years. It could be, 60%.
Yeah.
So there could be a huge differential. If they take it as community property with right of survivorship, both sides step up in basis. So there's not an issue on sale as far as a gain if they've had a huge gain in the property and now you've got too much house for the surviving spouse and they want to sell it, don't have to worry about a gain.
What effect does a stepped up in basis have on property tax?
The step up in basis has no impact on property tax.
Okay.
So there are a couple of other ways to take title vesting. You can take it, and this will affect those of you that sell investment properties. You can take title in an LLC or a corporation. If you take title in an LLC, you have members that are owners. If you take title in a corporation, you have shareholders that are owners. The property tax issue allows you to take the property out of an LLC and put it in individual names as long as it is the exact same ownership as it was in the LLC. So let's say Tom and I own a piece of property in the Bob and Tom LLC, and we decide, hey, we need to sell this property, or for some reason we want to put it in our own individual names. So as long as we put it in our names with the same percentage ownership as we had in the LLC, there's no property tax change. Same thing with a corporation. So you can go back and forth in those entities as long as the ownership doesn't change. You're fine. And according to the tax laws in California, if you have an LLC and you give some of the ownership to a third party or to a new party, that is a transfer of ownership, and it needs to be reported to the tax assessor. I'm sure everybody does that, and it will cause a reassessment of the property. Same thing with corporation. You transfer shares of the corporation, and that is reportable to the county tax assessor, and it will cause a reassessment of the property. There's some other issues, some issues related to that. I'll give you a real life example. So I've got a client who has never lived in Fresno, but has relatives and has acquired several properties over the years. And the properties were, try to remember, they were titled in I think they're titled in an LLC. And it's a married couple that are members, and they gave 10% of the LLC to their son. Well, now they're doing a trust, and they're trying to put the property in the trust. Well, it's no problem putting an LLC into a trust, except the son isn't a settlor of the trust. And so they couldn't put the LLC into the trust when he's got partial ownership. They've had these properties over 20 years. And as you know, property values have somewhat increased in the last 20 years. And so they have to get him out of the LLC. That would cause a reassessment. They couldn't put the property in their personal names because there's 3 of them that are owning the LLC. So that would cause a step up in base. So it could cause all kinds of issues. So people put property in LLCs or corporations to shield themselves from personal liability. And there's some legal issues with that. If you or a client are thinking about it, LLC is probably the best way to do it. They both shield from liability, but there's some legal reasons, there's some formality reasons that an LLC is better than a corporation. But don't think just because you have a piece of property in an LLC or a corporation that you personally are shielded. You have to play by the rules, or you can be gotten to.
Yeah. Bob, let me ask you this from the standpoint of family transfers. A mother or the parents can give a child a piece of property and the bases will transfer over with it. However, if the child decides they want to give the parents the property back, is handled like a sale. Is that pretty much, in other words, you can go from parent to child, but you can't go from child to parent?
Yeah, I believe that's correct, Tom. And you can also go grandparent.
Yeah.
And there are some limitations. You can give property up to a certain value.
Right.
So I think it's $1 million value. I always have to look it up because you don't come across it every day, but it's in the Revenue and Taxation Code for California. If you're ever interested and have nothing to do with the tax codes. All right, any questions on vesting? Well, let's get to all of our favorite topic, evictions. So I want to start with the CARES Act. That's the federal act because it's real quick and easy to cover. So the CARES Act affects properties that have federally backed mortgage loans, or they participate in a federal subsidy program such as Section 8. And so I know, so there's an eviction moratorium that was put into place with the federally backed mortgages. And it's a 120-day act. So the act, part of the act sunsets. We're not sure about the rest of the act, but part of the act sunsets after 120 days. And I think that is either passed or close to being over with. What the act requires is a 30-day notice to vacate. So no matter how long a person's been in the property, we know that if they've been there over a year in California, you've got to give them a 60-day notice. And if they've been there less than a year, you've got to give them a 30-day notice. But what about being delinquent on rent? What about violation of a covenant in the lease? You typically could give them 30-day notice, but a 3-day notice. But if they're a Section 8 tenant, you've got to give them 30 days. So before the Tenant Relief Act of 2020 in California, or AB 3088, came into being, with the CARES Act, you could give a 3-day notice to quit, 3-day notice to quit, but a 30-day notice, a 3-day notice to pay with a 30-day notice to quit. That would be the safe way to do it. The flip side of that is that there were no evictions pretty much during that period. So, so it's quiet as to that. So, excuse me. So that 30-day period may still exist after the law sunsets. We're just not sure. So if you do an eviction, it's a good idea to put the 30-day period in there just to be on the safe side, because you're not going to get them out before 30 days anyway. All right. So AB 3088, I'm going to start there and then I'm going to jump back to the Tenant Relief Act of 2019. So AB 38, which is the new law, requires landlords to provide notice about tenants' rights to all residents as of September 1st, 2020, who have not paid one or more rental payments that came due after March 1st, 2020, and prior to August 31st, 2020. that notice, according to the statute, must have been provided on or before September 30, 2020. So what if you didn't give that notice? Well, my advice would be go ahead and give it if it applies. Okay. So here's the rules. The new rules only apply. I can get my document too. There we go. There are a couple of periods that are set out in the statute. So there's rent that was due on or prior to March 1st of 2020. There is potentially rent that was due and unpaid between March 1st, 2020 and August 31st, 2020. And then there's potentially rent that is past due after August or starting September 1 of 2020. And those periods are all treated differently. So under the statute, it doesn't apply to rent that was due prior to March 1st, 2020. Except that you probably have to give, the 3-day notice has now been extended to 15 days under the statute. So based on that rent that was due prior to, I would recommend that you give a 15-day notice to pay or quit. And if it's subject to the CARES Act, 15-day notice to pay, 30-day notice to quit. And CAA has a form, I don't know if CAR has one as well, that provides that language. The notice that needs to go out for rent that's past due between March 31st and March 1st and August 31st must include a blank COVID-19 declaration. And that declaration is something that is signed under penalty of perjury by the tenant that says, I couldn't pay rent because I had COVID-19, or my job was interrupted by COVID-19. It was affected by, my ability to pay rent was negatively affected by COVID-19. That has to be returned to the landlord within 15 days, within that 15-day period. So you serve them, they get the notice with the blank declaration. They need to return that declaration to you within 15 days or pay the rent. If they don't return the declaration and they don't pay the rent, you can institute an unlawful detainer. There is a safe harbor period. So if the tenant has a good excuse as to why they didn't return the declaration within the 15 days, that period could be extended.
Now, Bob, where do we get the declaration? And we provide it to them, or they provide it to us?
No, you provide the notice, the 15-day notice to pay has to be served with the notice.
Now, what is this COVID pay? I have one of my buyers told me that he received a COVID pay of 25% on one of his rentals.
Okay, so we're not there yet.
Okay.
We're in the period between March 1 and August 31. So if the tenant doesn't pay, they give you this declaration, they still owe that rent. They don't get to not pay the rent, but the landlord can never evict them for non-payment of that rent. The landlord has to take them to small claims court to collect that rent. And they can't do that until March 1st of 2021. So good luck collecting it.
Yeah.
There's a provision for high income tenants. There's a high income declaration. So if you have tenants that are over 130% of the median, they're going to have to be pretty high income. They're going to be better rentals. There's a slightly different declaration that they have to fill out and sign. You can't ask them for their financials, but they have to declare that they qualify, and there's a little bit different. And I didn't really research that because I don't think it applies that often. People that are in that income range pretty much pay their rent and didn't lose their jobs for the most part. So that takes care of the period between March 1st and August 31st. I want to tell you, I have a client that was owed rent from January of this year, hasn't paid any rent. Just didn't feel like it. So my advice to that client was to just issue a 15-day notice to pay rent for January and February and forget about everything else. Likelihood of them paying it is slim. Otherwise, give them a 60-day notice and move on. So that's the period to August 31. Starting September 1, which now we're October 2, there's a similar notice requirement when you serve the 3-day or the 15-day notice. So you also have to give them the declaration. And if they sign that declaration, they get a little bit of relief. Well, actually, they get a lot of relief. They only have to pay 25% of the rent. But they have to sign the declaration. So with the declaration, they pay 25%. The other 75%, they have to pay by February, let's see, they have to pay the 25%, I'm sorry, is due no later than January 31st. So they have a breather on that. Landlord can file an unlawful detainer on 2/1/2021 if they haven't paid that 25% by then. The balance of the 75% of the rent has to be obtained through a lawsuit in small claims court. You can't go after it until March 1st of 2021. It doesn't matter if the tenant moved in after the pandemic began. They're still subject. They still have the same rights as somebody that's lived there prior. If you set up a payment plan with a tenant and it's affected by this period, they don't have to abide by this. Thrown in. I mean, if they stick to it, great, but they don't have to. The act does not apply to commercial tenants, which are defined as corporate renters. You know, if you rent to somebody as a corporation or an LLC, the act does not apply. It doesn't apply to transient occupancy, which would be hotels, motels, boarding houses, that sort of thing. Perfectly clear as mud. And that's all it is. It's a notice period. It's a right not to pay rent or to pay a limited amount of rent, and having to have a small claims action to collect for the landlord to collect the balance of the rent. So there's quite a bit of risk there. The other side of that is those evictions that you get aren't going to be reported. So the next landlord isn't going to know if they were evicted. So that's going to make things a little bit more difficult. Questions about the new act? Get unmute, Tom.
What's the reasoning for not recording the eviction, Robert?
Because your state legislature felt it was in the best interest of the tenants not to have to be penalized by the pandemic.
Yeah. Bob, I'm sorry, to all of you, one of the things that I decided a long time ago, as much as I know about landlord tenancy rights, the more I know I don't know. So I started a few years ago, and in fact, Bob has handled a couple of them for me. And in fact, I finally reached the point, I'm not even going to issue the 3-day or the 15-day notice, because you got to make certain that's correct, because if it's not correct, you're going to have to reserve it. So again, if I find myself in a problem situation, I'm right over there at Bob Abrams' office and say, hey, look, this is what's going on. What do you want me to do? It'll save you a lot of time.
Thank you. Okay, so let's go into the Tenant Protection Act of 2019, and more of you are probably familiar with that than with the new one, but there are some things about it that I think are worth sharing and that you need to know. So this affected tenancy. You know, it was you can't evict people that have been there over a year, basically, with some exceptions, unless they violate the rules or they don't pay the rent. And it's the just cause eviction. The other part of that same act is the rent cap. Okay, so I'm going to go through the 2 sections of the Civil Code that it affects, which is 1946.2 is the first one, and that is the just cause eviction. First thing that you want to know is that this law does not apply to certain types of real property. And it's a pretty generous exemption to the small property owner. So I'm just going to list a few of the exemptions that I think you would be confronted with your clients. So it does not affect housing accommodations in which the tenant shares a bathroom or kitchen facilities with the owner who maintains their principal residence at the property. So if you have somebody renting a room from you in your house, this law, the just cause eviction, does not affect it. It does not affect single-family owner-occupied residences, including a resident in which the owner-occupant rents or leases 2 or more units or bedrooms, including but not limited to an accessory dwelling unit. So if you have a mother-in-law house in the back, a second residence, it doesn't affect those as long as it's owner-occupied. One of them is owner-occupied. It doesn't affect a duplex in which the owner occupies one of the units as their principal place of residency, so long as the owner continues in occupancy. So it wouldn't work if somebody moved in temporarily to evict somebody and then move right back out. It would be a violation of that law. It doesn't affect housing that's been issued a certificate of occupancy within the previous 15 years. So newer residents are exempt. And here's the best one. It does not affect residential real property that is alienable separate from the title to any other dwelling, provided that both of the following apply. The owner is not a real estate investment trust, a corporation, or a limited liability company in which at least one member is a corporation. So it could be a limited liability company. It just has, all the members have to be real people. And the tenants must have been provided a written notice, or must be provided a notice that the residential property is exempt from this section, using a statement that says, quote, "This property is not subject to the rent limits imposed by section 1947.12 of the Civil Code and is not subject to the just cause requirements of section 1946.2 of the Civil Code. This property meets the requirements of those sections, 1947.12 D5 and 1946.2 E8, and the owner is not a real estate investment trust, a corporation or limited liability company in which one member is a corporation." So they have to be given a statement. Basically, this property is exempt because it meets these exemption requirements. So it's exempt from both the just cause eviction and the rent cap. That's going to apply to any house. So what does that mean? Do you all understand what that means, that exemption? It doesn't have to be an owner-occupied residential property. It just has to be residential real property, which in California is defined as 1 to 4 units, typically, that can be sold without any other dwelling unit. So that it has to be so it can be separated. So you're safe if it's a house, for sure. It's questionable if it's 1 to 4. But if it's more than 1. But as long as you can sell it, it's exempt by itself.
And
So
that was Bob, that was the form that we gave, right, to our tenants. I think it was last year.
Correct.
Single family.
But if you haven't given it to them, give it to them now. If you didn't give it to them by, I think it was June 30th this year, actually. Give it to them now. If you acquire it, if you're newly acquiring a property that meets that, give it to them. So that's a pretty good exemption. Now, if you've got apartments, it's going to affect you. So here's what the law says. After a tenant has continuously occupied a residential property lawfully for 12 months, an owner cannot or shall not terminate the tenancy without just cause. And that just cause needs to be in the notice to terminate the tenancy. If there have been adult tenants added to the lease before an existing tenant has continuously occupied the residential property for 24 months, then there's a little variation. So tenant's been there for 12 months, 13th month they add an adult to the lease. Then you can evict as long as all of the tenants have not continuously and lawfully occupied the residential property for 12 months or more. So that puts you at 20. If it's right after 12 months, that gives you 24 months in which you can give them notice. Or one or more of the tenants have continually occupied the unit for 24 months or more. So say, excuse me, say you've got a tenant that lives in a property for 10 or 11 months, they get married, move in their spouse, you have 24 months before just cause kicks in. Just cause is broken down into 2 categories: at fault just cause and no fault just cause. Of course, right? So at fault just cause is non-payment of rent, a breach of material term in the lease, committing a nuisance, committing waste on the property, criminal activity, subletting without permission of the landlord in violation of the lease. So there's a list of things that they could do that makes it a at fault eviction. The no fault eviction, or the no fault cause, just cause, includes an owner that wants to occupy the property either by themselves, their spouse, their domestic partner, their children, grandchildren, parents, or grandparents. And there's some exceptions to that. But if the owner wants to occupy it, what does this apply to? It doesn't apply to a single family house because that would be exempt, right? So all it applies to is if you've got an apartment building and you want to move yourself or one of your relatives into that particular unit. So as you start unwinding these statutes, it's kind of interesting is what they, I mean, they sound real complicated, and they are, but they don't apply to every particular property. It's mostly going to affect apartments. So you can decide to withdraw the residential real property from the rental market, or if the owner is complying with any of the following: an order issued by a government agency relating to the habitability. So if you get a red tag from code enforcement says vacate this property, you're okay in getting it vacated. An order issued, any kind of order that says you've got to vacate it. Sometimes you get a notice from the police department for criminal activity and they want the tenants out. That would allow a notice to vacate, and that would be a no fault just cause. I don't know why it's a no fault just cause, but it is. Criminal activity, though, is a fault just cause. So if you have an intent to demolish or substantially remodel the residential property, you could give notice. Now that has been somewhat tempered with the 2020 Act. And the substantial remodel isn't that you're going to go in and paint and replace cabinets or something like flooring, something like that. Substantial remodel means the replacement or substantial modification of structural, electrical, plumbing, or mechanical systems that require a permit from a governmental agency. So if you're going to do work without a permit, it doesn't do it. Cosmetic improvements, painting, decorating, minor repairs, other work that can safely be performed without the property being vacated don't apply. So before an owner can issue a notice to terminate the tenancy for just cause that's curable, the owner shall first give the notice of the violation to the tenant with an opportunity to cure that violation. If the violation is not cured within the time set forth in the notice, then a 3-day notice to quit with an opportunity to cure can be offered. So there's basically a 15-day notice and then a 3-day notice. For a tenancy that just cause is required, if the owner issues a notice, the owner needs to let the tenant know that they get a free month's rent. And they have to let them know when or how they're going to do that. So you can give them that free month's rent by not collecting the last month's rent, or you can actually pay them cash. So probably the best way to do it is just waive their last month's rent, and you don't have to come out of the pocket with any rent. But you do have to notify them. If you pay them out of your pocket, it's called relocation assistance. That's what this is called. That's how they soften it. It's called your ability to not pay rent. It's called relocation assistance. And that amount that you have to pay them is the amount of rent that they were paying. So if you have a tenant that excuse me, is grossly under market with rent, you win, as long as you have a just cause to evict them. Okay. The rent shall be provided within 15 calendar days of the service of the notice. So if you give them a notice you gave them a notice yesterday that their just cause tenancy is going to end at the end of the month, or I'm sorry, at the end of 60 days. Then you need, if you don't waive the last month's rent in that notice, within 15 days of the date of yesterday, you would have to give them a month's rent in cash, check cash. Follow that? Does that make sense? I mean, it doesn't make sense from a landlord's point of view, but do you understand what that means?
Can you repeat that one more time?
Sure. So remember, if they've been there over a year, you got to give them a 60-day notice to start with. So if you have a just cause to terminate the tenancy and you give them a notice on the first of the month, and that notice says they get next month's rent free, that's fine. You don't have to do anything else. If you give them the notice and you say you're going to pay them their relocation assistance instead of waiving a month's rent, you have to give them the money by the 15th of the month. And then you're 45, then they have to pay rent the next month and move out. So it's money you have to take out of your pocket. That's why I say it's much better if you notify them that you're going to waive the last month's rent. And you can't use their deposit to pay that rent. So all the other laws still apply as far as the move out inspection, as far as refunding their deposit and all of that. So it's just another layer of rules to put on. Yeah, but realistically, if you have a good tenant and they're paying rent, why do you want to get rid of them anyway? Unless, in fact, you have a relative that wants to move into the property, or that you want to move into the property. Good excuse to tell a relative all you can. Okay. So if a tenant fails to vacate after the expiration of the notice to terminate, the actual amount of any relocation assistance or rent waiver provided shall be recoverable as damages in an action to recover possession for an unlawful detainer. So if you waive the rent and they don't move, you can do an unlawful detainer for them. Now, what do you have to do? Well, if you gave them notice and they didn't move, that's all you have to do. You don't have to then give them another notice. They violated the notice. Other thing you should know, if a tenant gives you a 30-day notice to move, that they're going to move out, and they don't move out, you can immediately start an eviction. Okay, then we have section 1947.12 of the Civil Code, which is the rent cap. So it deals with rent increases. It again does not apply to residential real property that is alienable separate from the title to any other dwelling unit, provided that the owner is not a real estate investment trust, a corporation, or an LLC that has at least one member that is a corporation. So it doesn't include all of the same things as the just cause eviction does, but this is the broadest one, the residential property. The owner occupied statement in the just cause eviction, I'm not sure why that's even in there, because the residential real property that's alienable would apply. So here's the rent limits. Over the course of any 12-month period, an owner of residential property that's subject to this statute cannot increase the gross rental rate for a dwelling unit more than 5% plus the percentage change in the cost of living, or 10%, whichever is lower, of the lowest gross rental rate charged for that unit during any 12-month period. So if you raise the rent today 4%, you can come back and raise the rent more down the road, but there's a limit to how much you can raise it, and you can't raise the new rent. You have to, the raise applies to the initial rent. So if I'm renting for $500 today and I raise the rent by 5%, that's $25. So I can raise the rent to $525. Well, today in Fresno, the cost of living is 1%. So I'm entitled still to 1%. Well, let's say it goes to 2% before 12 months from now. Let's say 6 months from now it goes up to 2%. Well, now I can raise the rent another 2%, but not 2% of 525. I can only raise it 2% of 500. And then I'm locked in for another 12 months. So you're better off doing it all at once and doing it every 12 months and just put it on your calendar, and that's when you do it. So you can look up the cost of living. It's the, I'll get to it in my notes, but it's the labor amount. I just had to look it up recently, but it's pretty low, 1%. So right now you can raise the rent 6% present. Now, it still includes the fact that a tenant of residential property subject to section shall not enter into a sublease that results in a total rent for the premises that exceeds the allowable rent. In other words, if you can only raise the rent 6% this year, and your tenant thinks he's going to get smart, and he says, "Oh, I'm going to move. I've got a subtenant. I'm going to sublet the property. Here's his financials. Is that okay?" And basically, you can't turn it down unless can find some reason to. And they move that person in that 525 rent, but they tell the guy, "Well, I'm going to sublet this to you for $800 a month." Well, they can't do that. Okay. Let's see. Have I confused everybody yet?
Shelley had a question. Shelley, did you get your question answered? She said, what is the name of the form that we had to provide to tenants before June 2020? That's the rent, the just cause eviction, or?
Yeah, that was the notice that the property is either subject to these two sections of the Civil Code or it is not. And I think that CAR has that notice. In fact, I'm sure they do. The Apartment Association does as well.
Bob, a few years ago, the city of Fresno came up with a provision where, believe it or not, we have some landlords that are neglectful and keeping the property safe. And the city of Fresno had the ability, after notifying the landlord to do whatever was necessary and ensuring that they had proper notification and the landlord still refused to do it, they could come in and relocate those tenants into a similar housing situation at the expense of the landlord. Is that still in existence? It used to be called the POP team.
As far as I know, it is, Tom, but they don't do that as much as they come. They kind of go through a process, but some of the code inspectors that I've heard are power mongers. Some of them are not. But some of them will go, the first thing they do is they inspect the property. And as you know, they pick up every little thing. If there's any, I don't think they would go in necessarily and pick up a little thing if there was nothing. They might pick it up and send you a notice, but not a correction, not a correction notice per se, and say these things need to be fixed, but they don't give you a time limit or anything like that. If they find anything that they consider serious, well, like a smoke detector missing, they'll nitpick the property, and they'll give you a couple of weeks to fix it. And then they charge you for the inspection. And then they're going to re-inspect, and the re-inspection fee, for whatever reason, is way more than the original inspection fee because they're spending more time. It's a penalty. If you don't fix it, they start fining you. A $1,000 fine is the first fine. And some of them can be very difficult to deal with. But that's how they start with it. Before if it's real serious, and they deem it to be a habitability issue, they can red tag the property, shut it down, and relocate the tenant at your expense.
Well, Ange and I have a couple of, I have a 4-plex and a 5-plex. Every year I receive a notification from the fire department, and the fire department requires that I have that all of the smoke detectors are in working condition, and you provide proof of that. And all of those units have a fire extinguisher, and that fire extinguisher is updated. Now, it costs us to have the fire department that never goes in there to send the notice. I think it runs anywhere from $75 to $100. Then and I can guarantee you, as a landlord, I'm glad they do that, because it puts Angie and I in a position of making certain there's working smoke detectors, and the fire extinguisher is usable or is in working condition. I wish they do that across the board. See, I don't know, maybe, all these thoughts that I have in mind, maybe I'm just getting too lazy or something, but one of the other things that we're doing, as I'd mentioned, all of my evictions are handled by Bob Abrams. Also now, bringing in new tenants. I've discovered that the best thing for me to do is contact a good property manager, which I have discovered there's none better than Miss DeMastro.
I would just let her know that.
And I have her do the find the tenants at her fee. And then, so after the tenant's in, I take care of my responsibility as a landlord. But from at the beginning, at the ending, I'll let people do to make certain that it's done correctly. And I found that works good for us.
There are things to be said for being reminded by third parties that you have certain things to do. So in my office, we have to have fire extinguishers. And the fire department comes by, maybe not every year, but they have somebody that goes by and goes to all the commercial businesses and make sure that they have fire extinguisher and they're located in the right locations and they're properly updated. But when you update it through a company, that's how they do their business. They'll remind you every year that your
fire
extinguisher needs to be recharged.
Right.
So having that for smoke detectors would probably be a nice reminder, even if whoever sent you the notice. So.
We do it every year.
Yeah, and if you guys were talking about the Fresno baseline inspection, due to COVID, they actually don't come back to re-inspect. They were allowing the owners to send in pictures of the work.
Really?
I think that's the same thing.
Yeah.
Anything else I can answer or try to?
And Bob, how about if you find that a tenant has moved someone in? I mean, how can you prove that? And obviously that would be grounds for eviction, right?
Well, depending on what your rental agreement says. So your rental agreement becomes very important in your rules. So, you have to have a just cause eviction to move somebody, but you can change your lease. When your lease matures, you can't make the tenant move, but you can require that they sign a new lease. And if they don't sign a new lease, that's grounds for eviction. And in the new lease, you could have new rules. I mean, they can't be, if a court looked at it and said, well, you just put this rule in so you get rid of this tenant, right? You can't do that, but you can have more stringent rules for your property. And if the tenant then does not comply with the rule, then you go through the notice period to perform or quit. And if they don't perform or quit, then you give them the 3-day notice to perform or quit, and you can evict them. Now, there haven't been any evictions going in Fresno since March 14th, I think. They were approved to start September 1 by the state, by this new legislation. But Fresno County is taking till next Monday because they wanted to make sure that court personnel are properly trained. And they won't be. So if you're doing unlawful detainers, you need to be careful, and you need to be real specific as to what kind of an eviction you are requesting. Because if it's for rent, then it has to meet all the guidelines. If it's not for rent, you want to let them know it's not for rent, that it's an eviction for failure to comply with terms of the lease, or for criminal activity or something like that. So the court will be flooded on Monday. If you've been waiting to do some evictions, don't expect that they're going to necessarily happen real quickly. We've got about 5 in the pipeline that are just waiting till Monday right now. Dave, are you raising your hand or just stretching?
No, sorry, I that was a stretch. Sorry.
Bob, and
Thank
those
you, Bob.
evictions that you have, are they mostly for non-payment or for breach of contract, or? Is Bob frozen? I think he's frozen.
He talked to me. That was his first mistake.
You froze him. Now I see Patricia here.
do that.
Patricia, have you had any interesting cases with evictions lately?
Well, I worked with Bob just this last week, and I got an answer within hours. I needed to serve a 60-day notice to terminate, and it was just cause. But there were no forms that had a special saying on it because we were removing the property from the rental market. So Bob helped me with that, and I was able to go ahead and serve the 60-day notice. And like I said, he answered me within just like 2 hours. So I worked with Bob a lot, and he's always been a delight and very, very efficient.
Yes, he has. And what I like about Bob is if you call him and you give him, I called him to refer clients there, and he will say, Carmen, it's going to be more expensive for them to do this. They should just do this. So he's pretty honest. And
Doug Hefner, can you give me any good news on non-owner occupied refi cash out?
No, pretty much the same as it's been. Still restrictions. I mean, you can get them, but loan to values and stuff like that are going to be low. So, and it's going to be expensive.
I don't know what happened.
I think
Well,
Dave
you
Kidder
talked
froze
to
you.
Kidder. You talked to Kidder and you disappeared.
I know. He booted me.
And Patricia just gave you some nice compliments too.
Dustin,
Thank you.
back from anybody at the title company about Dustin Candler's loan or his something loan docs? I'm disappointed because you emailed at 8
Oh, I
o'clock.
think that's Angie back there.
Oh, I'm sorry. Thank you.
Okay, now,
Hey, Tudor,
Doug,
Scott.
did you just tell Tom that good luck on the cash outs?
Yeah, it's not necessarily good luck. I mean, you can still do it, but you're probably looking, and I'd have to check my guidelines, but it's probably 70% loan to value. You know, you're not going to get the low threes, you know, high two interest rates. You're probably going to be more than likely, you'll probably be in the fours in order to get that, you know, on certain things. So, I mean, there's a lot to it.
Doug, would it be easier to just do a refi, and not do a refi cash out? Or will we run into the same issues
Yes.
or challenges?
No, you'll run into some of the same issues, but no, cash out adds a huge amount to the fee, which means your rates are higher. So if you just did a rate and term, you probably have a little better. You probably go up to 75% loan to value maximum, and you know, it would go there, and you'd lower the interest rate to maybe the high threes or something like that. But yeah, it'd be a little bit easier. Whenever you dip into the cash out, that's when lenders right now are a little hesitant, especially with the COVID. It's all COVID related, and all the rules and regulations that are in place by the local governments and state governments, federal governments, that Bob just spoke about, as far as people not making their payments, people not being able to be evicted, lenders not being able to foreclose, those sorts of things. So when you talk about cash out and pulling cash out on an investment property, unfortunately, lenders think, oh, they're doing that because their people are not making their payments and they're looking to walk or whatever. So you're always guilty, and you have to prove that you're innocent. So before, and that.
It's like you can always get the money if you don't need it, huh, Doug?
You can always do that. So whenever the world is loosey-goosey on rates and qualifying conditions, you always borrow money then, because they're giving it away. But when you really need it, that's when they're not giving it to you. So it's always better to get it when you don't need it.
I know last night the market went crazy because of the news of the president. That doesn't affect your rates, the rates?
Yeah, yeah, it does, because the Treasury bill today opened up. It was like 60 T-bill, 10-year T-bill was 0.66, 66 basis points, and now it's bumped up. I just checked it a little bit ago. It went up to 70 basis points. And, you know, the stock market was down a couple 300 points. It's now, when I checked, it was down to about 60. The Dow Jones was down 68. So you're going to see some adjustments as news comes out about the president and what's going on and the uncertainty. Plus, it's a Friday, so you're going to get some hedging and some things. But so you get a little bit of adjustments today. I haven't had a price adjustment as far as rates came out this morning. There wasn't a price adjustment midday. If things get kind of crazy, you'll sometimes get an adjustment up or down depending on what's going on in the marketplace. But right now we haven't had that. So I mean, it's been bouncing around in that, you know, 65 to 70 range for the last couple of weeks. So.
Yeah. Any other questions?
Doug, do you do hard money loans?
Yes, I have access to some hard money.
Okay, I'll contact you later in a separate conversation. Can you just message me your contact info on the chat?
Okay.
Thank you.
You got
Yes, I'd like to ask Anthony, is there any word at all on what's going to happen in regards to Gerard and his burial at all, or with the family? Although this is probably a little soon for that, or is there anything the association is going to do, or where are we with that? Does anyone know?
I think he unmuted, but Anthony, we cannot hear you. And Tom, I think Dawn was going to be having a meeting regarding that, so we'll probably know more next week.
Good.
And I see Lori Buffington there. Lori, I know you had a rental you were going to sell. Did you sell that already?
Yes, it's under contract.
That didn't take long.
No, it didn't even hit the market.
Mm-hmm. Good for you.
Yes.
Well, guys, I think we'll call it an early meeting. Just so much happening, you know, this yesterday and today, and it's just a sad time for our association. You can see the sentiment here in the meeting today. It's you know, we appreciate you, Bob, coming in and sharing good info that, you know, we all need to hear and be aware of, and such helpful information. And like Patricia mentioned while you disappeared, you've been very helpful, and you know, with tenant issues to her, and I know to me as well when I've called you for advice or help for clients, and you've always been honest about, you know, whether they should pursue legal help, or, you know, might be simpler not to do so. So we appreciate that. Thank you for that. Anything else as we close, Tom?
No, thank you very much for having the meeting, and certainly let's extend our prayers to Mrs. Lozano and family. And I can guarantee you, in my 30 years, this has been one of the saddest experiences that I've had happen within our association. And boy, anything that I know that we can do at the Hyatt House for the Lozano family, we're going to do. You know, whatever their needs are, when we find out if there's anything we can do, we'll do everything we can to ensure it's filled. But let's certainly lift up our prayers to the Lozano family. Thank you.
Yes. Bob, they're requesting your phone number. Can I provide your cell phone number or just your office number?
Office number. Well, my cell phone number is in MLS. One of my cell phone numbers.
I'm typing it in, so I'll do it here.
What I do.
Carmen, I just want to say
There's the
thank you
number.
for holding this meeting.
Say that again, Dave.
Thank you for holding this meeting. I think this and other things going forward is exactly what Gerard would have asked for, and I think that's exactly what the MLS needs. We're still here to serve our customers, serve people, and we need to be informed. And thank you for holding this.
Thank you. And the association is closed today, correct? I think it's closed
That
today.
I don't know.
Thank you all, and have a good weekend. We'll talk soon. Take care. Thank you, Bob.
Thank you.